Okay, I think that might be everyone. Well, welcome and thank you very much for joining us for our Wilberforce 2020 Cayman Conference. You might have noticed that things look a little different and we're not in fact in Cayman. We're very disappointed that we can't be there with you today, but delighted that there are so many of you from Cayman and from London and further afield joining us for our first webinar. We're going to begin shortly with a talk from Tim Penny QC and Jamie Holmes on asset stripping claims and reflective loss. We're then going to move into separate Zoom rooms for a workshop of your choice, and I'll come back to that later. And then we're going to finish up today with some virtual networking, which is going to take place via Zoom, in which Hayley and Harry are going to manage for us. Just a few housekeeping points. This would normally be the point in the conference where I tell you where the fire exits are and where we're going to be having coffee later. But housekeeping now means something different. So if you could please keep yourself muted while Jamie and Tim are speaking so that we can avoid background noise. And if you've got any questions, please feel free to put them in the chat function. We'll also have a few minutes at the end if you've got any questions there. And finally, we recommend that you use speaker view in Zoom, so changing your view in the top right hand corner of your screen rather than gallery view so that you can see Jamie and Tim properly. Right, I'm now going to hand over to Jamie and Tim.
Thank you, Liz. I hope I can be heard. Can I be heard? Liz, can I be heard? Very good. Thanks very much. Hello, everyone. Morning, everyone in Cayman, and afternoon, everyone in London and elsewhere. Jamie and I are going to deal with a recent case that we've been involved in Cayman, instructed by Ogier in Cayman and Mishcon in London, called Raiffeisen Bank and Scully Royalty. The judgment deals in part with the law of reflective loss as it was under the Court of Appeal decision in Marex, prior to the Supreme Court decision in Marex, which came out 7 days after the judgment Mr. Justice Parker in Cayman was handed down. Before I describe the background of the claim, I ought to make three preliminary points about the claim. Firstly, the claim is not yet at the direction stage, and it's at the serious issue to be tried or good arguable case stage in terms of injunctive relief and permission to serve out of the jurisdiction. Secondly, the claims that I'll refer to that are made by our client, the bank, are hotly contested by the defendants. And thirdly, the injunction that was granted by Mr. Justice Parker and is the subject of, in part, the judgment on the 7th of July 2020 is subject to an appeal to the Cayman Islands Court of Appeal that's likely to be heard next September. So you'll understand that there's a limit to the opinions and views that we can state in relation to our case, in relation to the law. But nonetheless, it's, we think, an interesting case study in relation to the Fraudulent Dispositions Law Cayman and the issues arising in relation to reflective loss in the context of a tort claim. So, Jamie, if I could have the first slide.
Yes, I'm just going to jump in now and share my screen.
Thanks. So, our client is the creditor. It's an Austrian bank which has a number of written guarantees provided to it by a company that's called, what I'm going to call Old MFC, to the total value of about 90 million euros. The guarantees are governed by Austrian law and are subject to Austrian arbitration agreements. Old MFC, the guarantor, is a former Canadian parent of the MFC group. It was listed on the New York Stock Exchange and held directly or indirectly all the shares in the MFC group of companies, all the subsidiaries, and valuable mining rights to an iron ore mine in Canada. So enter the company New MFC. There was a restructuring approved by the Canadian court, pursuant to which a NewCo was incorporated in Cayman. That new co is New MFC. New MFC became the new parent company, top co of the MFC group, and took over the New York Stock Exchange listing from old MFC. Old MFC thereby became a subsidiary of New MFC, and after that occurred, pursuant to the restructuring, New MFC was redomiciled from Canada to the Marshall Islands. So the transfers, the subject of the Cayman litigation that we're involved in, occurred post-restructure and broadly involved transfers whereby old MFC, by then a Marshall Islands company, transferred all of its assets to New MFC or to group companies owned by New MFC. Old MFC was then transferred out of the MFC group, becoming a shell company with no assets. As a result, when RBI came to make demands against old MFC under the guarantees and came to consider making a claim against old MFC under the guarantees, it discovered that old MFC, the guarantor, had no assets left. All of the assets were held by New MFC Cayman, or companies in the MFC group, which are subsidiaries of New MFC, and those companies are incorporated variously in Canada, Malta, the Marshall Islands, and so on. Thanks, Jamie. So our case theory was and is that old MFC had been asset stripped by New MFC Cayman. Its direct, by its New MFC's 100% subsidiary called New MFC 2, and a number of other subsidiaries incorporated in Canada, Malta, the Marshall Islands, and elsewhere, whilst under common directorial control. We allege, and these next two bullet points are really the core of the case because it's common ground that the assets have been transferred, that old MFC's assets were transferred to New MFC, New MFC 2 and the various subsidiaries at an undervalue, or indeed for no value. We say nothing having been paid to old MFC in consideration for the transfer of the assets. And finally, we allege that the transfer was for the purpose of putting old MFC's assets beyond the reach of old MFC's creditor, the bank, which you'll recall is owed up to 90 million under a number of guarantees. So RBI wished to take steps to ensure the availability of the assets for the purposes of enforcement before launching an arbitration claim in Austria under the guarantees. So what the bank did was to issue substantive proceedings in Cayman against New MFC, companies in the New MFC group and old MFC, by reference to the following courses of action. We issued a claim under the Cayman Fraudulent Dispositions Law 1996 revision, which is the Cayman equivalent of Section 423 of our Insolvency Act 1986, although it's an act that has received little attention in the decided authorities. And we also launched a claim in the tort of unlawful means conspiracy, the unlawful means being, among other things, the asset stripping of old MFC at an undervalue in order to defraud the bank. We obtained an ex parte worldwide freezing injunction, modified freezing injunction in September 2019 against New MFC, and we issued a claim against 4 companies, obtained permission to serve various group companies outside the jurisdiction, including and in addition, old MFC, which you'll recall is now incorporated in the Marshall Islands, and a return date was set for January 2020. There was a contested hearing for 3 days in January 2020. In February 2020, Mr. Justice Parker handed down a ruling giving permission and upholding permission to serve outside the jurisdiction and granting injunctions against the 2 Cayman companies, New MFC and New MFC 2. And it's those injunctions that are the subject of an appeal to the Cayman Islands Court of Appeal. Thanks, Jamie. So really on this talk, there's only time to make a couple of headline points about the claim under the Fraudulent Dispositions Law, which, as I say, is broadly similar to the provisions of Section 423 of the Insolvency Act 1986, although there are some significant differences. Mr. Justice Parker held that there was a serious issue to be tried for the purposes of service out and a good arguable case for the purposes of an injunction. He also held that Cayman was the forum conveniens and that the foreign parties were necessary or proper parties. And I've really tried to distill in this slide a number of the more important territorial cross-border points emerging. The first point perhaps isn't particularly important, which is that the claimant, the plaintiff, of course, the bank, is domiciled outside the jurisdiction and hasn't yet commenced an arbitration claim under the guarantees. But nevertheless, under the terms of the Fraudulent Dispositions Law, it is a creditor. See a case, the Cayman case, Johnson and Cook Bodden, which holds that there's no need for the plaintiff to be a judgment creditor to assert a claim under the FDL. But perhaps more importantly, the final 3 bullet points we think are significant. First point to note is that the property that was transferred by old MFC, the Marshall Islands Company, being shares in group companies and mining rights, was situate outside of the Cayman jurisdiction. So there were group company shares transferred in companies in Malta and dealings in relation to companies in Canada and dealings by companies in the Marshall Islands and dealings with mining rights in companies which own rights in Canada, an iron ore mine in Canada. So all of the property, or much of the property that was transferred, was situate outside the Cayman jurisdiction. Next point to note is, of course, that the transferor, old MFC, the guarantor, the debtor, was domiciled outside the jurisdiction in the Marshall Islands. And the final point to note is that many of the transferees or ultimate transferees of the assets transferred by old MFC, shares in group companies, were and are domiciled outside of the Cayman jurisdiction. But nevertheless, the court held that there was a serious issue to be tried, that claims lie under the Fraudulent Dispositions Law in relation to those transfers against those foreign recipients. The final paragraph of this slide, I draw your attention to possibly one of the most interesting aspects of the judgment of Mr. Justice Parker in relation to the FDL claim, which concerns the issue of whether, to what extent can you as a claimant, a creditor under the FDL, obtain rescission and transfer back of the transfer of assets exceeding the value of your claim. So let's say, for example, that the bank has a claim. Let's assume that the bank had a claim for 50 million euros against old MFC, and that old MFC had other creditors to the tune of another 50 million euros. If the bank only achieves the transfer back of 50 million euros of assets, it will only get a pari passu dividend on the winding up of old MFC. On the other hand, if it can get a claim, get an order under the FDL for the transfer back of 100 million of assets transferred, even though it only has a claim to 50 million, then its claim in the liquidation of old MFC can be satisfied in full. And I suggest that, importantly, Mr. Justice Parker found that where the debtor is insolvent, the FDL gives jurisdiction, at least arguably, to set aside sufficient of the transfers to allow the creditor plaintiff to have the full extent of its claim satisfied. So let's move on then to the tort claim. So we included in the writ a claim for damages, a claim arising out of the tort of unlawful means conspiracy, the unlawful means being the asset transfers at an undervalue with the intent to defraud creditors. When we made the ex parte application, obviously we needed to be aware of the possibility that that claim would be the subject of a reflective loss defence based on the English Court of Appeal decision in Marex. And that, if it did apply, would extend to extinguishing our claim for damages, a claim for damages against the recipients or the conspirators, payable directly to the bank. So what we did was we pleaded alternative claims for relief that we considered didn't fall within the reflective loss principle as it then stood, including a mandatory injunction requiring the return of the assets to the debtor, old MFC, and or damages payable to the debtor, old MFC, rather than to the creditor, the bank. And we contended, and the court accepted, that it was at least arguable on the ex parte stage that that those claims for relief fell outside of the principle of reflective loss. Why might the reflective loss principle be engaged in this case? Well, we considered that it was likely that the defendants would assert that a claim by the bank as creditor was a claim for the same loss as was caused to old MFC by the default of its directors, i.e. old MFC could have sued its directors and indeed the recipients of the assets for damages for asset stripping the company and for the return of the assets. And our claim as creditor effectively was for the same loss. And so we considered that it was possible that the reflective loss principle might be engaged. And at the January return date, the defendants did duly argue that the tort claim was barred by the principle relying upon Marex in the Court of Appeal, as it then stood, and two Cayman cases called Zikun and Primeo. And Jamie, if we could just go on to the final slide. So I'll just tell you what Ms. Justice Parker found in relation to the reflective loss principle, and then I'll hand over to Jamie. Mr. Justice Parker rejected the submission that reflective loss principle was engaged at all because the unlawful means claim was based not on the breaches of duty by old MFC's directors to old MFC, but by the unlawful asset stripping of the corporate debtor. And two, and most importantly for our discussion today, because the relief claimed fell outside the scope of the reflective loss doctrine. And I'll leave you there with some quotes from the judge, who found that it does not apply to the grant of relief other than damages. And whereas in this case, the damages sought are payable to the debtor rather than the creditor, he referred to the Zikun case, which he said makes it clear that if the rule bars the action in damages, that does not mean there's no injunctive remedy available. He held that the reflective loss principle does not apply to the grant of relief other than damages, and in particular doesn't apply to the grant of a mandatory injunction. And it applies only so as to prevent the recovery of particular remedies. And he repeated that in the paragraph at 138. Damages are paid to the debtor rather than to the creditor instead of a mandatory injunction. The reflective loss principle does not apply. So that was his judgment on the 7th of July. And I'll hand over to Jamie to explain to you the principles that emerged from the Supreme Court decision that was handed down a week later.
Thank you, Tim. As I've set out on the next slide, they're the dates that Tim has just referred to. Now, the decision of the Supreme Court in Marex had been anticipated for some time. The case had been heard back in 2019, and when judgment was handed down on the 5th of July, there had been quite a lot of anticipation about quite which way the Supreme Court was going to go. Now, some of you may be familiar with the decision of the House of Lords in Attorney General and Blake, in which Lord Nichols famously began his leading speech with the sentence, "My lords, George Blake, who was the defendant, is a notorious self-confessed traitor," leaving perhaps little doubt as to the outcome he was likely to reach in the remainder of his speech. Now, Lord Reed's speech on behalf of the majority in Marex might be said to have begun similarly, with its first line being, "This appeal concerns the supposed principle that reflective loss cannot be recovered." And that principle is now dead in the dust. But that's not to say that it's gone completely. So the rule against reflective loss as it had come to be understood following the decision of Johnson and Gore Wood in the House of Lords in the UK, which is the only previous decision of the House of Lords or the Supreme Court on the rule, is gone. And instead, the Supreme Court has reinstated the rule in Prudential. Prudential being the Court of Appeal decision back from the 1980s, where the reflective loss doctrine has sort of grew out of. So reflective loss is gone, and we now have the rule in Prudential, as it's repeatedly referred to by the majority. And I've put a quote up on the screen. There are a number in the judgment that set it out, but it seems to me that this is probably the most succinct. That you'll now only need to worry about reflective loss where you've got a claim by a shareholder. And even then, the shareholder's got to be bringing a claim that as a result of actionable loss suffered by their company, the value of their shares or the distributions they receive as shareholders has been diminished. And then in terms, other claims, whether by shareholders or anyone else, should be dealt with in the ordinary way. So this is a fundamentally different beast to what we were dealing with before. And I want to draw out on the next few slides six ways in which it's similar and different, some of which are shorter and longer than others. So it's probably, although in some ways slightly more abstract, probably the best way to appreciate where all of this comes from is that the Supreme Court considered the rule to be, or at least the majority, considered the rule to be based on a fundamentally different policy platform to how it had been considered in all the decisions really since Johnson and Gore Wood. There's a handy summary of this by the Court of Appeal in Marex and by the Cayman Court of Appeal in Prudential that I remember Jack took you to at our conference last year. Now we're told this is very much a special rule about shareholders. And you can see that in particular in the quite short concurring speech of Lord Hodge. And in that quote I put up on the screen, paragraph 51 in the much lengthier judgment of Lord Reed for the majority. Now, other policy considerations that have been mentioned before, such as double recovery and the need to protect the autonomy of the company, are still mentioned. They've not gone completely, but they're very much seen as subsidiary or secondary considerations to this primary basis for the rule. And from all that comes the following. Now, where you fall outside of the rule, that's been my second point, how any issue as to double recovery might be dealt with will depend on the circumstances. And essentially, it seems the Supreme Court considers this will be dealt with by the trial judge. And this might happen in a number of ways. You might not have a black and white rule where one claim gets priority over the other, and not priority sort of in a looser sense, in the strict sense that only one person can bring it. You might deal with it by some form of accounting between the parties, some kind of cross set of obligations, or by more established means such as subrogation. And that's about the extent of what we're told, really. The third point is that where you fall within the rule now, any such loss as you may have in fact suffered as a shareholder with one of those two types of claim is irrecoverable as a matter of law. Now, there are really two short points here. One is that the rule does not bar a cause of action of such, and I'd say that's one to sort of file away for the future, because it may be of significance in deciding other points about the rule at a later date. But the main point to draw out here is it was at least previously understood or often said. You may recall there was a speech of Lord Bingham in Johnson and Gore Wood, which sets out a 3-point summary of reflective loss, which is quoted and followed in a lot of the subsequent cases in England and in Cayman. And it was often suggested in light of that if you could show that you had in fact suffered separate and distinct loss, then you were outside the rule. The majority says that is not the case. If you fall within that test I set out in the previous slide, that is it. So my final 3 points then are, number 4, the rule remains a hard and fast rule. It is not a discretion. You cannot get around it that way. The 5th point then to bear in mind is that whilst on the one hand having very considerably narrowed the rule, the Supreme Court has removed, it would appear, all of the previous exceptions to it. The case of Giles and Rind has been explicitly overruled, and the line of authority that Tim took you to that was considered by Mr. Justice Parker in Raiffeisenbank has been disapproved. The rule applies just as much to claims for damages as for other forms of relief. So there's very much sense of giving on the one hand and taking away with the other here. And finally, again, there's more one to sort of file away for the future. It would appear that the Supreme Court, although it didn't directly deal with the point, treated the rule as one of company law. And so it seems to me that is consistent with a decision I was involved in KMG and Chen, where it was held by the English High Court that it's a rule of substance and not procedure when you're thinking about this with your conflicts of laws hat on. I wanted to very briefly mention the decision of Big and Smith, which was decided in September following Marex. This essentially just applied the majority on a number of points, as I referred to on the previous slide. The interesting potential development here is that it suggests that the rule is going to be applied very narrowly, at least in England. It held the rule did not apply to claims by what were called second or third degree shareholders. And so it only was a plaintiff who was the immediate shareholder that was caught. And it'd be interesting to see if that gets unpicked or revisited a little in future decisions. There have already been other decisions as well on the rule. The decision of Nebu and Daniel Stewart that Daniel Lewis and Chambers was involved in. As I said, it was much anticipated for some time, and when it came out, a sort of flood of decisions were released at first instance that had been waiting for it. The very last thing I just want to cover off on my slides, as it feels remiss not to mention it, is the minority in Marex came to exactly the same conclusion on the actual issue on the appeal, which was whether it applied to that particular claimant and him who was a creditor, and they unanimously held that it did not, but they did so for very different reasons. In short, they didn't think the majority went far enough. They thought that trying to scrape the rule back to Prudential was a bit optimistic, and it was questionable if really it should just go entirely. In a little more detail, the crux of the point seems to have been that they felt that it should be open to a claimant to prove that they had suffered distinct loss in fact. You recall I mentioned this before, whereas the majority said, no, it's a rule of law, that's it. And they said, well, if double recovery can be dealt with in cases outside of the rule, like the majority says, why don't we have that approach for parties who can prove distinct loss in fact as well? And so sort of move the bar one further back. And they also disagreed as to what the policy basis was, and they held it actually was all about double recovery and not a special rule for shareholders. But it seems to me that's slightly less of interest. But that first point highlights that this point that it is a rule of law and not one that you can get around on the facts. I think that's everything I wanted to point out from this decision of the Supreme Court. And I'm gonna hand back to Tim very briefly, as I'm aware that we are approaching the end of our time.
Thanks, Jamie. Just to really wrap up and say, obviously, the consequence for a case such as ours in the Cayman Islands, brought in the capacity as a creditor, is that assuming the Cayman courts apply the Supreme Court decision in Marex, our sort of claim is now no longer caught at all by the so-called old rule against reflective loss, and now the rule in Prudential. So our case no longer engages the rule at all. Thanks very much. Thanks, Liz. I'll hand back to you.
Thank you. Well, if anyone has any questions, feel free to turn on your video and ask them or type them in the chat function. I just had a quick one. I think you've probably half covered it, Tim, but in your concluding remarks. But do you think that the Marex decision now means that all those kind of reflective loss claims which were creeping into fraud claims are now dead and buried? Or do you think there might be some creative way of twisting even the restatement of reflective loss in Marex to fit, I think it's like your Scully case?
Seems to me to be a relatively hard and fast rule. You're either within the rule in Prudential, in which case your claim is excluded, or not. There may be cases where claims are made by the same party with multiple hats on. Claimant and creditor and shareholder hats on, where the precise dividing line may be the subject of argument. But
that's the difficulty, isn't it? Where there's someone who's a shareholder but also claiming in another capacity, and their claims as shareholder will be precluded, but their claims in another capacity might not be.
Jamie, do you have anything to say?
I think just to add that if you are a shareholder claimant in a fraud claim like that, it's not necessarily the end of the road. All of the previous ways people have come up with in the last 20 years to get around the rule may, it appears, all be gone. But you can still rely on the conventional remedies that any shareholder has, and the Supreme Court set all of that out in their judgment. You can still try and bring a derivative action. You might still try and bring an unfair prejudice petition. You're just stuck with the deal you struck with the company. It's sort of how the Supreme Court saw it. You've got to either be the majority and bring the claim as the company, or rely on your claims as a minority shareholder, or that's it, is one way of summarising what the majority said. So it's not the end of the road. There are still things you might try and do.
Yeah. Okay, I don't think we've got a question from Michael DeVere. Michael, if you want to share your video, you can ask it. Otherwise, I'll ask it. Michael's asked, does Marex overrule the right to seek specific performance, such as in oceanic shipping? Tim, what do you think?
If you fall within the rule, then it doesn't matter what the remedy is that you claim. So the old cases of Peak Hotels, and it may be that the Marol case may be the same oceanic shipping case, I'm not sure, but those cases have gone now with the Supreme Court decision. You can't sidestep the principle by making a claim for specific performance or for a mandatory injunction or some other alternative remedy.
It's all about the capacity that you're claiming in.
Indeed.
Yeah.
I think just as a small point of detail to add to that, and I'm going to jump back through the slides very quickly. That was one of the points considered in the Big and Smith decision. I don't know if you can see my cursor, but I'm moving it along the bottom there. So that's that first instance High Court decision has already got straight into that point. And I think in that case, the exact remedy claimed was specific performance, or if not, it was a very similar one. So that might be the place to start looking if you want to sort of try and work out what the position is. Or that of course is the English law position anyway.
Okay, I think we're going to head into workshops now.